Hello, partyist of the people, and welcome to episode 3 of season 6 of Law and Candor, the podcast wholly devoted to pursuing the legal technology revolution. I'm very excited today. As you all know, my name is Bill, and I'm here with Rob. It's nice to have you with us. We have a great episode today. We're going to be talking about reducing cybersecurity burdens with a customized data breach workflow. It's an interesting topic, interesting conversation. But before we get to that, we have to get to the favorite portion of our program,
Sightings of Radical Brilliance.
This is where we bring to you the best of noteworthy innovation and acts of sheer genius. Roberto, what do we have?
Yeah, for a lot of us and a lot of our clients, transferring data between the EU and the US is something that we deal with a lot. And we've kind of relied on this privacy shield framework for a long time. But recently, the European Union has struck down the privacy shield as a valid way of protecting data. And this really creates a big problem for a lot of people, especially because there's not an easy solution for it.
I just, you could have seen this coming, right? So we joke all the time, or our clients joke all the time. There's no such thing, or European clients joke about this all the time. There's no such thing as privacy in the U.S., and it's scary. But when you have the policies that protect the employees the way the EU does, I could see why they say that, right? Because all of the data for discovery purposes, data on a computer, on a work computer here in the U.S. is considered work and professional data. Therefore, it can be collected. In the EU, it's just not like that. So there's always been a bit of a tension between the two. But here, basically what they're saying is until the U.S. changes their laws, this is not good enough, and we're just not going to comply.
Well, and it's complicated because, under the privacy shield, you would make representations about how you would handle that data coming from the EU. But what the court's saying is it doesn't matter what representations you make, because the U.S. surveillance apparatus is still going to examine that data, and until you fundamentally change their right to do that, you really can't guarantee that you're going to protect this data, and that's a tough hurdle to overcome.
I love the statement in the article. This guy Max Schrems, who's a privacy activist and a party to the case, explained the reason behind the court's decision is the following. This is great. No, he did not pull any punches here. The court clarified for a second time now that there is a clash between EU privacy law and U.S. surveillance law, as the EU will not change its fundamental rights to please the MSA. The only way to accomplish this clash is for the U.S. to introduce solid privacy rights for all people, including foreigners. Surveillance reform thereby becomes crucial for the business interests of Silicon Valley. Shout out to Silicon Valley lobbyists to start lobbying for the privacy of European citizens. I get why. I get what he's saying. I get his point. I'm not holding my breath. I think it'll be interesting to see what Silicon Valley does in the absence of lobbying the U.S. government to change their privacy law, because they do have to do business in Europe. Obviously, it's a huge market, but I'm not holding my breath for it. It'll be interesting to see. I know there's a lot more consumer privacy regulations coming out in the U.S., but that's got more to do with disclosing what you have rather than prohibiting what you can take.
Bill, we don't make a lot of predictions on this show, at least not a lot that are taken seriously, but I am going to predict that this issue will not be resolved before we get to season 7 of Law and Candor.
I think it's bold that you think we're going to get to a season 7, but yeah, I agree. Even if we didn't, I think your bet is safe. I think that this is something that I feel like ever since you and I have gotten into this industry around the same time, within a few years of each other, and I just feel like this tension between EU privacy and U.S. Lack of U.S. privacy law has been in tension since we've gotten into it, going 15, 20 years now. So I agree with you. I think we have a better chance of solving the Middle East than we do of solving this within the next couple of years. All right, let's get to the interview portion of the program. Really excited. The topic is essentially cyber. And we're going to talk about the ability to reduce cyber security burdens via a custom data breach workflow. Interesting stuff. If cyber is your bag, you're going to want to listen to this episode. Enjoy.
All right, welcome to the main event. We're excited to be able to sit down with Jeremiah Weasenforth from Orrick. This is going to be a real interesting edition. We talk a lot about data security and cybersecurity in general, but I think this is the first time that we've dived a little bit deeper into how you actually respond to a cybersecurity incident and what kind of workflows and technology that people are using to do that. And Jeremiah, we've started recently, instead of just giving a generic background on, what you do or what your role is we've tried to switch it up a little bit and ask, how is it that you ended up in this e-discovery industry? I think if there's anything we've learned from the podcast is that everyone has a pretty interesting story, and we'd love to hear yours.
Yeah, so I've been in e-discovery for over 10 years now, and I kind of fell into it. Came to Orrick, helping with some e-discovery matters, really on the litigation side, and just kind of fell in love with the work. It really started from running my first e-discovery project and getting really into the technology and sort of nerding out over that. I've always been kind of a tech guy and was able to handle one of Orrick's first TAR projects almost 8 years ago. And so since then, I became the TAR guy. I was the person who...
That's a dangerous title to have.
There's no doubt about it. It's a busy one, but I really enjoyed it. And it sort of just evolved from there into the role that I'm currently in today, which is really managing a team of folks who don't think about law the way people in a law firm typically do. We're really sort of right where technology meets law. That's where we live. When I go to hire people, I don't hire your traditional lawyers, your traditional paralegals. We've got a statistician. We have other data analysts on staff. I have a guy who we joke about that he likes to code in Excel on the weekends. Like that's his way to unwind. That's what we're looking for in our group. We're not looking for folks who want to get really deep into employment law. Not that there's anything wrong with that. We're looking for folks who care about the technology side of it.
So Jeremiah, before we dive into it, can you give us a little background here? Why are data breaches so costly, and what are the burdens of a major data breach?
Well, I mean, the first thing to note is they're completely different than anything anyone is used to in e-discovery. A lot of folks are used to, you find documents, you tag documents, you use them either to produce or to identify key documents for an investigation, some kind of witness interview, something like that. And the scale of what you're doing in a data breach is just completely different. You're looking for PII in unstructured data, right? Across emails, across loose files, in a way that's not formatted properly. And then you need to find that PII and connect it to those individuals wherever it exists. So document 1 might be my social security number, right? Document 1 million might have my driver's license. And then other pieces are interspersed all in between. So it's a completely different proposition from what we're used to doing. A lot of our companies, a lot of clients are targets for these breaches among hackers. And then you have to deal with, every jurisdiction, every state has some kind of different requirement on what qualifies as PII. So there's really restrictive laws. There's laws that say, just the bare minimum, the social security number, the driver's license, your account numbers, all of that stuff. But they also have different notification procedures. Some will give you 60 days, others give you 30. And so it's not only that it's completely different and no tool was really designed to handle it, but it's also that timeline is so compressed. If somebody gets into, 10 mailboxes, that may not seem like a lot, but, depending on how folks store their data and whether they have a strong information governance standard at their company where they're deleting emails, that could be millions of records that we have to dig through and find whether we have access to certain individuals. And then once you find those individuals, you have to figure out where they are. Are they in Washington State? Are they in New York? Where are they and what rules apply? And what do I need to notify them about in the end that their data's been exposed? I just think there's so many different variables going into it, and also tools that have not been built to handle that kind of work has really made it way more complicated than I think anybody expected.
Well, and even without the tools and the technology, it's almost like a 3-dimensional document review. Like we're kind of used to that standard coding panel, but to have different privacy requirements by different states and try to overlay that into review, that's got to be pretty complicated.
It is. And I think one of the things that we did early on is we decided that whatever the most restrictive state was, or whatever the most restrictive provision was, that was the PII that we were going to capture for everybody. We weren't going to try to suss out, okay, this person's from West Virginia, so I need these 5 pieces of PII. Rather, we're going to capture it all. And then when we go to make the report, that's when we can call down what kind of PII was actually exposed and what we need to notify that individual about.
So it sounds like the common denominator is that there's some kind of PII that needs to be identified. And then once you've identified it, you've got to tie it back to the actual person that it's connected to. And, we talk a lot about this in the context of data breaches, but what about things like, DSARs and, the new CCPA Act? Are you also involved in those types of matters?
We are involved in those kinds of matters, and those are still difficult, kind of a different beast than an overall data breach, but really along the same principle, right? There's personal information, there's data that is out there that, that individual is requesting or that we need to comply with in some way, shape, or form. And so it's sort of along the same approach, what we're trying to capture. We're going to end up bringing back and pulling that into a report and giving to that individual. And if they make the request to delete or whatever that is, those are sort of similar steps, but still complicated. And, I think it's interesting to think about where the regulations and where the laws are headed, especially as, the CCPA is introduced and, that starts to come more stateside rather than being over in Europe and other places.
All right, Jeremiah, it's time to geek out a little bit. So I understand you work to create a custom data breach workflow to overcome some of the similar burdens we're talking about here. So what are the pain points that you encountered more specifically here?
Well, so first you need to figure out how you identify the PII, right? And this has really sort of been a trial and error, see what works and see what doesn't kind of approach. But, at first it was, let's run some search terms and try to identify PII. Well, that's, not that helpful when you could have 100,000 form documents that for a healthcare company that say date of birth without the date of birth actually there. So, we really dug into regular expression type work to identify that PII. So some advanced searching to find, numerical combinations, things like that. And then over time, it's evolved again because companies are starting to see a hole in the marketplace. So we didn't have any machine learning technology, and the machine learning technology that we were able to train, predictive coding type tools, weren't built for this, right? And so it's one thing to train a tool to capture a concept. It's another thing to train a tool to capture a 9-digit number, right? And so we're getting better at that. And I think that companies in general have started to develop some machine learning tech that allows us to identify that PII on the front end. But that was the first issue. How do we get it? How do we get a population that's reasonable and defensible and that makes sense for our clients? And how do we get that population to not be so overly broad that we're hitting on 80% of the data that we're putting into a system?
It kind of reminds me of just e-discovery in general, when it first started. And, like initially you just kind of brute forced review. And then the next thing you knew, you had hundreds of reviewers, working on a single project, and it just got out of control. Then technology started to improve and make that process a little bit easier. Are you seeing a similar, trend in this? Is there technology, I guess more specifically, that's helping you?
We're definitely seeing growth. We're not only seeing companies that are designing tools that are solely for this, but we're seeing traditional e-discovery tools repurposed in a way that makes it easier to find this kind of data. There's a lot of sort of custom tips and tricks that we've developed over time to help find this data. But I think the more that the technology can get there, the more that we can cut out some of the manual labor side of this. I mean, it's just going to benefit everyone, and it's not going away. I mean, data breach is so prevalent. Personal data is the new oil. I know everybody says that, but I mean, it is true, and it's constantly being exposed out there.
So the interesting thing here is, I'm going to try to summarize some of this stuff, but I mean, it's just, I think you just touched on it. It's not going away. Again, everybody says it's the new oil. It actually overtook oil as the most valuable commodity in the world, right? PII. So in terms of like summarizing it, why is it so costly? Well, data breaches expose PII, right? Bottom line, when that happens, and it does so in a way where it's not easy necessarily to get to, because you have to connect it all back to the individual subject. Then once you realize that, now it's like, where is that subject located? What rules govern it? What laws govern it? I think you touched on a little bit about DSARs and CCPA. every state is going to try to outdo each other with regard to their consumer protection laws. And that's just going to make things harder. And so the technology's got to catch up to this, because all of these regulations are putting companies in a position and their attorneys in a position where they're trying to figure out a way to comply with best efforts and best intentions, but without the technology there, because frankly, a lot of these, the way the PII is being used within organizations isn't necessarily structured for compliance and reporting back. And so that some of the, whether it's a custom workflow that you've used to, as Rob said, in the beginning of eDiscovery, it was just sort of a mass manual effort. And we're trying to, I think, as a technology catches up, workflows like the ones you're developing will be able to leverage that technology to keep companies in compliance within the defined period within the individual regulation or statute. But it's not going away. It's an incredibly serious problem that is confronting all these organizations and corporations that are not only operating within every state within the United States, but globally. And it's an interesting problem, and there's no wonder why you're hiring statisticians instead of lawyers on your team and have to do a very different interview process than, let's say, the average partner that's hiring for a real estate lawyer.
No, I was just going to say that absolutely. You really have to think about it in a way different than the eDiscovery work, right? So there are some very basic things. One, you don't care about families. You don't care about an email and its attachment. It's which of those documents has PII in it. So we're used to deduping at a family level. You can dedupe at an individual document level because you don't care that this attachment exists 50 times in the database. I only need to see it once. And so there's little tricks like that you can really use to call down on the data set. And then you can, you really need to figure out a way to make a unifying piece of PII object or however it's called in the database for one person. So when I'm looking for Jeremiah Weasenforth's PII, I need to be able to tie it back and do it in a way that's not manual data entry and it's not just tagging. And so you really have to set up a system that when I have a new name, I can connect those pieces of data back. The best companies are really starting to do that in an automated way using machine learning tech, all of that stuff. But even if you're not doing it that way, there's other steps that you can take to tie it back, working with your vendor, doing some scripting, things like that really make it a lot easier.
I would assume the more automated we can make this process, the easier it's going to be to comply going forward. And that might be where the technology is headed, right? If you can figure out a way to manually tie all this stuff back, that's great. But to do it within a defined time period, as stated by a regulation or a statute, that's going to be a tricky part.
That's the way you avoid 100+ people, typing somebody's name differently every time that they get in. I mean, you think about that. You've got 100 people typing my name. I mean, my last name is complicated.
I was just going to say your name. Yeah. Just first of all, one of the best names I've ever heard, by the way. Just my compliments to your parents. But Jeremiah Weasenforth probably has been typed out 1,000 different ways in the last hour and a half, depending on how many people are trying to get in touch with you.
Just my first name, anytime I make a Starbucks order, it's a wildly different outcome every time. So.
Yeah, Jerry and Maya, we have your drinks. Jerry and Maya, yeah. Jeremiah, this has been fantastic. I really think that this is something that's going to be an ongoing issue. I think our audience is going to get something out of this. And I could see us coming back to you in season 7, 8, 9 and beyond to check in on this, because I think the technology ultimately has to catch up to the issue. And I would love to check in with you on it. So if you're up for it, we'll probably send you a bunch of emails that'll go to the wrong place because we'll misspell your name. But inevitably, if we can reach back out to you, I think you're certainly a guest we'd like to have on in future seasons to catch up and do a where are they now on this issue, because I just think the technology is going to explode in this area.
I would love to talk about it again. I think we're in the Wild West days of data breach review, and we'll get there. But we've got some work to do.
Thanks, Jeremiah.
Thanks, everyone.
Law and Candor Nation. This is Rob, and I want to thank you for your support. And again, we're just putting out a request. Like us, give us a good comment, rate Law and Candor. We really need your support. Just imagine what would happen if we didn't have enough support and I was taken off the show and you were left with Bill talking to you nonstop the whole time. Please do not let that happen. Subscribe, support. Thanks for your help.